represent the plaintiff and petitioner, Commissioner Joe Carollo.
Good morning, Judge De La O. For defendant Miamans for an Independent and Accountable Mayor's Initiative, also known as in the plea Mr. C. Strong Miami, that's the U.S. name, Ben Cuney of the Cuney Davis Law Firm.
And Marcos Jimenez.
Okay. Do you represent the same entity?
Yes, Your Honor.
Okay. Who else is here on behalf of the defendants?
Your Honor, tentatively, we are entering a limited appearance for Francis Suarez. That matter has to be settled out, but we don't want the mayor to go unrepresented, so we have authorization to tentatively represent him until we can determine appropriate representation.
Okay.
Good morning, Your Honor. John Greco, Christopher Green, George Weissheim from the Office of the City Attorney. We're not actually entering an appearance because we have a conflict of interest, and we ask that Your Honor allow as much time as you can for us to secure counsel. We are working very diligently on it.
But you'll be able to answer questions today, even though you have a conflict, as a friend of the court?
I will be a friend of the court, of course, and I'll do my best to help you.
Thank you, Your Honor. Warren Rosenthal and Michael Valdez on behalf of Supervisor White. I don't need to stand on this side to indicate any affinity to one position or another.
But I have a column in the middle.
But you have a column and you have limited geography.
Right.
We represent the ministerial defendant, Supervisor White, and our issues to be heard on are going to be the potential relief you will have given the timing of the election,
Right.
and maybe it's a substantive issue depending on how this case goes.
Okay. Nobody else? That's it? Okay. Well, Mr. Rosenthal, stay there, because I think you're going to be able to answer most of the questions I have for today.
Okay.
The reason I set this hearing for today was to try to figure out the timeline by when I need to make a decision, and obviously make a decision with enough time to allow for appellate review and for the election to go forward if it needs to go forward. So anything you want to say about that?
I'd be happy to, Your Honor. The supervisor is ready to print ballots today. Today, the Lieutenant Governor choices are going to be announced by law. The one thing that's holding up a certification from the state are 5 pending cases, 4 before the Supreme Court and 1 before Circuit Court, that have to do with constitutional amendments proposed by the Constitution Revision Commission. We expect those to be done by the end of the week, and Monday the supervisor, whether or not she gets a certification, will be printed. Just to give you a little idea what she has in front of her, on September 21st, vote by mail, which is the current name for absentee ballots, need to be sent out to overseas voters. On October 9th to domestic voters, that's 350,000 ballots that need to be mailed out for the November election. Those ballots are not just a single page, they're 4 pages, so she's got to program, test, and print over 1 million pieces of paper within the next couple of weeks. So if the relief requested is to take this item off the November ballot, that needs to be done today. If not, there's an alternate relief, and I've already given this to the parties, and I'll hand it up to you if I may approach her. This is a guideline from the Secretary of State given to all supervisors of elections. One of the other reliefs that's been upheld by the 3rd District Court of Appeals is to post a notice. If the court has taken an item off the ballot, we would insert notices at the city's expense into all ballots that get mailed out at all polling places that essentially say this referendum question has been removed by order of the court, and therefore any vote won't count, and the final results will suppress the results in the final tally, and there will be no official vote taken on that item. And so that's the relief that I would propose. That relief will afford this court additional time. You still may want to keep yourself apprised of the September 21st overseas date and the October 9th domestic date, because that will allow us to start stuffing ballots with that notice so that the voters are apprised of your action.
But if the notice doesn't go with those ballots that are being mailed overseas and domestically, I could still order that that the vote's not counted.
You can still, well, the votes will still be tabulated, they just won't be reported and they won't be officially certified by the supervisor. Because once you order and tell the public that this is an illegal ballot question, if you choose to, I'm not saying you should or shouldn't, but if you choose to, once it's ordered and not stated and it's a final order that's enforceable, any vote that's taken thereon is tainted by that order. And so I think any vote thereon would be ineffective.
All right, so Mr. Suarez, what would you tell me about what briefing schedule I should issue?
Your Honor,
When I should
first,
have a hearing?
thank you. We appreciate the supervisor's position. We understand the constraints that the supervisor of elections is operating under, and we by no means are asking the court to alter that schedule. We know that the supervisor will
work diligently to give whatever effect it needs to anything that Your Honor may order. With respect to the scheduling of the matters before this court, we have presented a 5-count complaint and petition for emergency writ of mandamus. The first 4 counts relate to the declaratory and injunctive relief that we've requested. The first count requests the court invalidate the ballot language because it is unlawfully vague and ambiguous.
I've read your entire
Understood.
petition. I'm more interested right now in case management. How long do you think you need to brief all the issues? And then I'm going to ask the other side how much time they need.
The second matter is also what we believe a purely legal matter, and I'm trying to limit my comments just so that I can put them in the frame of reference of the scheduling relief. The second one we think is also purely legal in the sense that the petitions were circulated by the unlawful circulators, and the fourth, which relates to the unconstitutional log rolling argument, argued yesterday extensively before the Supreme Court, I think is also a purely legal issue. And those 3 counts can be advanced on a very expedited track, and we can get those teed up legally as quickly as the court will entertain them. The third item relates to the allegations that there was actual fraud in the conduct of the petition circulation process. That count is going to take a little bit longer to tee up before Your Honor, because we need to be able to take the appropriate discovery to put on the evidence before this court that there was fraud in the process of gathering the petitions by the committee and those working for them. With respect to that, we would request that Your Honor order expedited discovery and set us for an evidentiary hearing within 2 weeks.
Okay. Mr. Cunha, Mr. Jimenez.
Thank you for this expedited status conference, Judge. We too agree that this case is appropriate for expedited relief. A briefing schedule may be a bit more complicated than the plaintiff has suggested, but I want to add 2 things to your court's consideration. First, noting that we will work with the court and the parties to move this along quickly. We know the court moves quickly. We certainly have the capacity to move quickly. But the court needs to recognize in setting that schedule that the plaintiffs waited 3 weeks from the operative action of the City of Miami Commission to put this on the ballot to bring the lawsuit. That means that the court should be cognizant of the fact that it takes some time to put together the right approaches to what are legal issues, and then we recognize there are some factual issues. With regard to the legal issues, Your Honor, to the extent that we can get to definitive briefing, not on procedural items such as proper parties, which will have to come to you with some litigation about that. We think that probably 3 weeks or less is good for us to do our briefings, and I would just note the reason I say 3 weeks and not 2 weeks is I have some Jewish holidays next week and the following week which are set on the calendar, and they do not interfere in any inappropriate way, but require some additional time in setting the stage to get our pleadings done. So we think we're close with the plaintiffs. We would like to get this matter definitively resolved soon, but we do agree with what the county attorney says, that we can't imagine a ruling that's definitive before Monday. We think that would be an unwise use of judicial resources to try to push to get a decision by Monday.
So I'm thinking of hearing the first week of October. I need to pull my calendar out and look at my dates, but I believe I start my special set week the week before October the 8th. So the week starting approximately October the 1st. I'm going to do what I can right now to move some special set motions around, see if I can clear up an entire day. It does sound like there's only one of the counts that I'll need to have an evidentiary hearing on. The rest will just be argument. You would agree with that, Mr. Suarez?
That's correct.
Okay, Mr. Cunha, Mr. Mendel?
Yeah, we think that's fine, that first week in October for a hearing. As
think by the time we start the hearing, I would hope you all would have proposed orders ready to go. And then I'll work as expeditiously as I can after the hearing to modify the orders to my findings. Right, anything else I need to know today, Mr. Suarez?
Your Honor, I'd like to hand the court for your consideration a writ of mandamus. With respect to count 5 of our complaint, we have requested that the court order let me rephrase that the court enter a writ directing the city clerk to disqualify ballots that were circulated by ineligible petition circulators, or in the alternative, as set forth in the writ procedure, that the city clerk show cause why he has not done so.
Your Honor, I don't believe this hearing is set for entry of any order other than status, number 1. Number 2, the complaint itself doesn't even set forth a cause of action for mandamus. Third, there are numerous factual issues that undergird whatever their claim for mandamus is. And finally, mandamus is a sought remedy in this case, and that remedy should be determined at the close of the evidence and legal argument. So
Why do you say
premature.
Why do you say it doesn't set up for the cause of action?
There's no verification. It's simply a lawyer's statement. There's no certified copies of documents that are appended. There's no affidavit that says these facts are true. Frankly, I can't imagine a lawyer would argue these facts are true if they don't know the facts. So procedurally, it's not even in the right place for the court to consider a writ of mandamus.
Why wouldn't I wait till the hearing we're going to have in October to issue the writ?
We are not asking the court to enter any relief with respect to the ultimate issue as to whether the strong mayor initiative should be placed on the ballot. We are asking the court merely to direct the city clerk to identify which of the petitions were circulated by ineligible petitions and to disqualify them. If Your Honor does not wish to take the additional step today of having those petitions disqualified, I would suggest and would tender an alternative writ that the court simply direct the city clerk to identify which of those ballots were circulated by non-registered voters in Miami-Dade County as required by County Ordinance 12-23, so that that process may inform the rest of the proceedings before the court.
Why shouldn't I do that?
The court recognizes the limited nature of mandamus, which is to compel an administrative officer to do something they have a duty to do. This sounds like a discovery request and a request for early discovery. They have not cited to a single provision of law, of charter, of policy that requires the city clerk to do whatever it is they're asking. And frankly, I haven't heard that there's been a refusal, that they made a request to the city clerk. So given their determination that a mandamus is appropriate, that this court is being asked to exercise its extraordinary authority to direct a governmental officer to do something that a governmental officer must do by law and has no discretion in deciding what to do. They've not even set out the preliminary steps for a mandamus, and if the court goes to look at the complaint doesn't even set out those procedural / substantive requirements for entry of an order of mandamus. We think it sounds like a discovery request.
It does, but issuing a show cause, why I shouldn't grant the writ of mandamus would seem to make sense that the clerk comes in here and starts to explain why I shouldn't.
But, Your Honor, first of all, there's an underlying assumption here which is not true, that these are ineligible petitions, that these things should be disqualified. We haven't had any argument on
But that would be the city's response. And the clerk would walk in and say, well, the reason I haven't done it, the reason you shouldn't issue a writ is that they are eligible, or it doesn't apply in this situation, or whatever the response is.
If the court wants to have the city participate with the clerk, that's fine, but certainly there should be no order that the clerk take any action.
Well, I agree, I'm not gonna order the clerk to identify any ballots, but if you'll upload a proposed order that simply orders the clerk to show cause why I shouldn't grant the writ of mandamus, then we're gonna join them into the lawsuits where they can be represented.
I think they are, Your Honor, I know the court has directed that, I want to be heard before an order to show
Well,
cause.
we do have Todd Hannon already in here, so why am I gonna issue an order to show cause?
Mr. Hannon is a party. We were asking for the court to enter the mandamus relief for the sole limited purpose of identifying which of the petitions were circulated by ineligible petition circulators. Mr. Hannon is the party that can make that determination. It's a party that has all of the criteria to make that determination.
Is he refusing to make that determination?
To date, he hasn't.
Has he been asked?
I want to temper my result. I know it's been a subject of discussion before the commission. I don't know that there has been a square demand for that to be done.
All right, so then, I'm not gonna issue the show cause, because the reason I was gonna issue the show cause was to bring the clerk in, but I overlooked Mr. Hannon already being listed, so I think his interests, or the city clerk's interests are already represented, and I'm not gonna order him to make a determination that nobody's asked him to do yet. I think it is a discovery request. We'll be able to take his deposition and ask him who's eligible, who's not. If he refuses to answer, or refuses to make that determination, then I think it falls before me.
Very well.
Anything else today?
Nothing else today.
Okay, Mr. Kim.
Judge, in terms of scheduling, we would like to have a briefing schedule presented to you. Would the court prefer that the parties try to work out agreement on what we think is an ideal briefing schedule?
Always.
And at least for today, we work backwards from, should we say, October 1?
Not yet. I'll get back to you all. My secretary will call you and tell you what the date will be, and then you all can try to work on the order. If you don't reach agreement on the order, then each of you put up your competing proposed orders, scheduling orders on my e-courtesy, and I'll create one. But I will get back to you early this afternoon with the date for the hearing.
Second, Judge, in terms of some of the preliminary initial cleanups, we would ask the court to set soon a hearing on the status of some of the parties. Basically, it deals with parties suing individually or being sued individually versus in their regular capacity. The parties may be able to work some of those out, but I think that's an important procedural issue that's going to need to be resolved fairly early on.
Will you be ready to address it by Tuesday?
I'll have to speak with my co-counsel Monday and Tuesday. I am unavailable because of Rosh Hashanah, but
About next Thursday?
certainly.
I'll set you all for 8:30 a week from today. Somebody notice it, please, and then we can address that issue. And if anything comes up in the meantime, my motion calendar doesn't start till 9:15, so you'll have at least 45 minutes. We're not going to address any matters.
So we'll set a status on whatever we call it for 9:13 and 8:30 a.m.
9:13, 8:30 a.m.
Thank you, Judge.
Anything else today?
Nothing from the defendants that we represent.
Nothing further from us. Thank you very much, Your Honor.
Thank you all. I'll see you next Thursday.
Thank you, Your Honor. Thank you, Your Honor.